Today we are going to discuss defamation. The premise of defamation is holding one liable for causing damage based on their statements or writings. There are 4 elements that constitute common law defamation and are found in the prima facie case. They are: 1. A false and defamatory statement. 2. That is, of or concerning the plaintiff. 3. That is published intentionally or negligently, and 4. Causes damages. When there are matters of public concern or the defamation concerns a public official, 2 additional elements are required, which are fault and falsity. Let's go through each common law element first, then we will go through the 2 newer elements, and then we will take a look at defenses. The first element is a defamatory statement. A defamatory statement is one that may negatively affect a person's reputation within his community. Typically, an opinion will not qualify as a defamatory statement. The second element is, of or concerning the plaintiff. This requires that a third party would recognize the defamation as being about the plaintiff. If it's not clear what the defamatory statement was, the plaintiff can use external facts to plead colloquium. Additionally, there are rules that allow members of a group to demonstrate that a defamatory statement was made about them specifically. The next element is the requirement that the defamation was published either intentionally or negligently. The intent is the intent to publish, not the intent to defame. Publishers and republishers are all potentially liable. The fourth element is damages. Damages are broken up into 2 categories depending on the form of defamation. If the defamation is verbal, it's called slander. If it's in a more permanent form such as a writing, then it is called libel. Because spoken defamation is considered less permanent and therefore less harmful, both general and special damages must be pleaded and proven. There are 4 instances when slander does not have to be proven due to the harmful nature of the defamatory statement. They are classified as slander, per se. The 4 areas are criminal activity, loathsome disease, unchastity, and business statements that may be harmful. Since written defamation or libel is more permanent, it's considered to be more damaging, and therefore general damages are presumed and special damages do not need to be proven. Those are the 4 elements of common law. As the idea of defamation has changed and evolved in the late 1900s, the Supreme Court added 2 requirements that are now required of the plaintiff. Due to these rulings, freedom of speech and First Amendment rights under the Constitution must be taken into account. Previously, causes of defamation were considered to be false, but with these new rulings, now the plaintiff must prove that the statement in question is false. When the matters are of public concern or involve public officials, fault must be shown on the plaintiff's part. However, the status of the defendant will determine the level of fault. From the case of New York Times v. Sullivan, if the plaintiff is a public official, the defendant must show there was actual malice. As defined in this case, actual malice means that the defendant knew the information was false or had a reckless disregard of the truth or falsity of the statement. Defenses. Defendants in a defamation case do have a few defenses available to them. They are: consent, truth, and both absolute and qualified privilege. Consent by the plaintiff and truth of the statement are always defenses to a defamation charge. Absolute privilege is granted to those who are involved in judicial, legislative, or executive proceedings, as well as to communications between married couples. Qualified privilege may be a defense as long as it is used to protect the public interest or under the fair comment rule. However, the privilege may be lost if the statement is not made in the scope of the given privilege. Thanks for watching. We hope that this helps with your studies.